All right, hello everyone. My name is Bradley Chaplick. I am live streaming to all of you from my basement during the stay-at-home order. So thank you all for joining me, and let's answer some of your questions. This is our condo law live stream. If you are new to the stream, please don't forget to subscribe, and you can put all your questions in the chat, and then I will answer them. And so there's a few things we want to talk about today. One of the things we want to talk about is the current stay-at-home and lockdown orders and what you can and can't do. And then we'll also talk about some of the workplace outbreak reporting requirements for Toronto condominium corporations. It's my understanding that there are similar requirements in other jurisdictions in the Greater Toronto Area. Oh, Catherine's saying I'm echoing. I will, let's do this. Okay, did that fix it, Catherine? Am I still echoing? I just unplugged my microphone. If you can still hear me, and Catherine, can you put another text in and let me know if you can hear me? Just want to make sure I'm sounding okay for everyone. All right, so I'm going to assume you can hear me unless someone says you can't. And I'm going to start talking about what's going on right now in the, I see the questions coming in, that's great. Okay, I'm going to start talking about what's going on right now in the stay-at-home and lockdown orders. Okay, so if I'm looking over to the side, it's where I've got all my notes on the screen here. So first thing in the stay-at-home order is work from home. So staff must work from home unless the employer, depending on the context, this could be management company, property manager, if you're talking about staff who report to the property manager, or the board of directors instructing the manager. So unless your employer says that your work, it's necessary for you to be in attendance at the workplace, you have to work from home. So some condominium managers should be working from home at least some of the time, but of course there are tasks that require you to be on site, and for those tasks you can be on site. So it's going to depend on your individual circumstances as to whether, as a condominium manager, you can work on site or work from home. If you're on site, you're supposed to be wearing a mask, and your management office should not be open to the public, i.e. to unit owners and to anyone else coming inside. So those are the basic ideas for condominium managers and the stay-at-home, work-from-home order that's in place. I know a lot of managers want to be on site. They feel like they need to be there, and in my view, if that's the situation, you should confirm that with the board of directors or with your property management company, and then you can work on site. So I'm just going to jump into a couple questions here, and then I'll turn around and we'll start talking about some of the lockdown orders. So Phil asks a question. Good afternoon. In the case of an apartment building that is registered as a condominium and owned by one shareholder, so unit owner, does the board need 3 directors? And if so, can the shareholder be all 3? Great question, Phil. There's a clear answer to this. The Condominium Act says that the minimum number of directors in a condominium corporation is 3. So you cannot have fewer than 3 directors. They need to be 3 different people. But of course, if you have one unit owner who owns all the units, that person can choose who the 3 directors are. And they can be, the unit owner and then, maybe 2 other members of that person's business or family or whoever they want. But you do have to have 3 different directors, and the directors should have meetings at which at least 2 directors constitutes a quorum. So you are not exempt from the requirement to have a board of directors, even though you are operating as an apartment building. You're still a condominium and you have to follow the rules. Things like reserve fund studies and all that stuff still apply to you. So let's see, what else do we have here? Cheng Wang asks, is it mandatory to install hygiene barriers at the concierge desk? So assuming that you are in the City of Toronto, there is a letter of instruction from the Chief Medical Officer of Health, Dr. Eileen de Villa, you will find a link to our summary of that letter of instruction in the description for this video immediately below me. So if you open the video description and you look down, I've linked our summary, and that summary also includes a link to the copy of the full letter. And in there you will see, yes, that if the concierge, if there's two people there, I was thinking about something different. I was thinking about if you have two people at the desk and they're within 6 feet of each other, then you need a barrier between them. Your question, Chang, might be different. Your question might be, do you have to have it in front of the concierge, as to act as like a window for interacting with people? And the answer would be you could, or you could just put like tape around the floor showing like a 6-foot barrier that people can't come within. So if you're going to have people come within 2 meters of the desk, then you should have a hygiene barrier. And if not, you can just do it with tape on the floor. So I hope that answers your question. But yeah, read the letter. The guidelines from Eileen de Villa are pretty clear. So, but there's a lot of different things you have to do for providing a safe and hygienic work environment for your frontline, front-facing staff. Great question. Paulette. Hi, Bradley. Question re passing a bylaw for virtual meetings. Please confirm how many owners must approve the bylaw. We are hearing different. 50% plus one, or majority of those present at the meeting. It's the latter, Paulette. Majority of those present at the meeting. So a virtual meetings bylaw is called a low threshold bylaw, meaning that it is not the traditional 50% plus one, which is for normal bylaws. It's just the majority of those present at the meeting. So let's say you have 100 units and your quorum for your meeting is 25 owners, 1/4. So let's say you have the minimum number of 25 people attend your meeting where you're going to approve your virtual meetings bylaw. The threshold to pass the bylaw would be 13 out of 25. So not 51 out of 100. Hope that answers your question. Great question. Chang asks, is it mandatory for a security guard to wear a mask sitting at the concierge desk with enclosed barriers? My understanding of the rules is yes. So yes, Chang, my understanding of the rules is that if you are at work, you are now required, and your work is like indoors, you are required to be wearing a mask. So that would apply to everyone, including people in offices and stuff. If you're anywhere where you could be within 2 meters of other people, you're wearing a mask. And my reading is that you're actually wearing a mask all the time if you're at work. So yeah. Okay. Phil asks, again, I'm just trying to run through your questions here, and then if we get a quiet spot, I'll just talk about some other stuff. Phil asks, if the units are owned by one person and rented, can the shareholder be 3 directors? Does he have to be registered with the condo and take a condo course and be registered? Okay, this is more about the situation of a condominium corporation that has a single unit owner. So all the legal requirements for directors apply to your condo, Phil. So yes, the directors have to take the training course within 6 months of being elected. You have to give their information to the CAO. They might not necessarily have to be unit owners. It depends on your bylaws. I would expect that your bylaws don't require directors to be unit owners. So it could be any people who the unit owner elects. But in every other sense, yeah, you have to follow all the same rules for directors as everyone else. So going back to Chang, is it acceptable if there are sides open with barriers at the concierge desk not fully enclosed? Chang, it's hard for me to know without seeing it, but if you read Dr. de Villa's letter, she describes the fact that there should be barriers, and she doesn't go into any more detail. Of course, the barriers are not going to be airtight. There's going to be openings. There's going to be gaps. So I would say to Cheng to just do the best you can to create a environment that protects your staff. But yeah, of course, there's going to be openings at the side and all these things, or at the top. So because of the practical limitations of you can't put people in a sealed plastic box all day. So you just do the best you Dreadbane. Good afternoon, Brad. When a purchasing law office clerk requests to provide if the current owner has any outstanding amount in his unit statement, are we allowed to disclose it? Okay, that's an interesting question. So you should you have to disclose it in a status certificate. So the question is this. The question is, you're the manager and you receive a request from a purchaser, the representative of this purchaser, in this case it's the lawyer, wanting to know that the common expenses are up to date. That's because it's a condition of their closing, right? They want to know if they have to hold back money from the sale to pay the previous owner's unpaid common expenses. That information would be found in a status certificate. And so what they're really doing is calling you to ask for an update on that information and make sure that nothing has changed since the date of the status certificate. If I were you, if you were worried about privacy, I would ask the purchasing lawyer to make the request through the seller, through the vendor's unit owner, right? And that solves the problem if you're worried about privacy, right? You just say to the purchaser, have the request come from the seller so that we're communicating directly with the unit owner. You provide the answer to the seller's lawyer in an email, or send a copy of the ledger showing zero balance, and they can flip that to the purchaser's lawyer and satisfy the condition. So the information can be provided, and if you're worried about privacy, you can provide it to the unit owner, him or herself, and not to the purchaser. Or they can ask for an updated status certificate, in which case you would provide it then. But it's not a huge privacy issue if it's for the purpose of a purchase. I think that's pretty normal. So there you go. Dreadbane. The law clerk also mentioned that as per the Law Society rule, the status certificate is valid for 3 months to close a transaction. I don't know about that. I mean, a status certificate is current as of the day that it's given from your perspective. Maybe from the perspective of a lawyer doing a closing, like due diligence, they say don't rely on a status certificate that's more than 3 months old. Fine. I mean, that has nothing to do with you. You're not doing the closing. So that's up to whatever people are comfortable with. You don't even need a status certificate if you want to close. You can just close without one and take your chances. It's all due diligence. So I guess maybe they're saying there's some sort of recommendation from the Law Society saying make sure your status is not more than 3 months old. I would want it more current than that. I would want it, I would want my status to be up to date within a few weeks of closing. I would probably order one when we do the deal, and I would order another one right before closing. Like I would order it 2 weeks before closing so that you get it at least a few days before, and then I would check it again. But that's just me being super cautious. So there you go. Harland. Does the CAO have a list of the names of all members of the board of directors? If so, where can I view it? If not, where would I find this information? Yes, Harland, they do. If you go on the CAO, Condominium Authority of Ontario website, you will find that they have something called a public directory, or public registry, I think it's called. And the public registry, you type in the name of the condominium corporation. So you would you would say like YCC 111 or whatever, and then you would say like, yes, I'm not a robot, click submit, and then it pops up all the information. So it tells you when the condo was registered, who the directors are, when they were elected, who the property manager is, manager's contact information. All that is part of the public registry, and that's all on the CAO website. So I would just type CAO public registry into Google, and it should be like first or second hit. Pete. Hi, Brad. Can the condo corp evict pets causing noise nuisance during lockdown? Good question. So the courts are open for urgent matters. Whether a pet causing noise or nuisance would be considered sufficiently urgent to get you a court date is a tricky question. I think it would have to be pretty serious. But let's say you're just talking about sending a letter declaring a pet a nuisance and demanding its removal within 14 days in accordance with your rule. Sure. No reason why you can't. I mean, use your discretion, right? Maybe you want to give people more time to comply, or like a warning or something like that, because it might be difficult for people to find a place for their pets or move. You want to be sensitive to these issues. So I would say do your best to resolve it amicably. But yeah, the rules still apply, and your pet rules are still enforced. Nothing suspends them. It's not like when the provincial government said that residential evictions for non-payment of rent were suspended. There's no such order for pets, if that's your question. All right, Catherine. Lots of questions today. Everyone's been really busy. Okay, so here we go. Catherine, a resident owner urinated in the elevator. Oh no! She was informed that she would be billed for all cleaning, disinfecting charges. She informed property management that she has a disability and says she excluded from any expenses paid by her. I'm sorry for laughing. I've actually had this happen before. Does this absolve her from her responsibility to pay costs? No. No. Okay, let's talk about why. This is a great question. So the question is, does having a disability exclude you from the obligation to pay costs for damage to the property that arises from your disability? And the answer is no, and it has to do with the undue hardship test. So I'm going to use a slightly different example, Catherine, to prove the point, but I think it should become clear. Let's say you have a resident who uses a service animal. So for whatever, like classic example would be a blind person's seeing eye dog, right? So if the seeing eye dog defecates in the lobby and leaves a big mess, and the condo has to clean it up, the person who owns the dog is still responsible for the pet's mess. Now, in this case, we're talking about a person, but the principle is the same. So you might you would have to accommodate that person, but it doesn't mean that they're not responsible for damage to the property. Like that goes beyond what the obligation to accommodate means, right? It would be like, take another example, right? Let's say you have someone who has a medical disability that like maybe causes seizures or something, and they get a seizure while they're driving in the underground garage and they drive into the wall. Does that mean they're not responsible for the car accident? Like, no, they're still responsible. It's very sad and unfortunate, and of course we want to approach these things in a very light, sensitive way. But no, the disability does not excuse the person from the cost to repair the damage or clean the mess or do any of those things. We don't accommodate things that damage the property. It doesn't meet the undue hardship test, so meaning that it's not something that's expected to be accommodated. But it's an interesting question. Has come up with me before. I had a person who was incontinent using the pool, and the resident was fouling the pool, and the question was whether she could be allowed to continue using the pool, and that was a tricky question. I mean, no one's saying that this person shouldn't be able to use the elevators, just that they have to clean up. So, okay, let's see what else we got here. Sherwood. No COVID-related question. Great. Building EV charging station expenses. Can the board use a reserve fund account to pay for installation? I don't think so. So the question is, can you use the reserve fund to pay for a common element EV installation? My answer to you is I don't think you can. That's because reserve funds are for the repair and replacement of existing common element amenities. This would be there's actually a specific provision in the EV regulations that talks about how these installations are funded and what the rules are and when you have to get unit owner approval. And so the answer is no to reserve fund, and check the regulation, or send me an email and I will send it to you, and I can show you exactly what the threshold is for these expenditures, and they should be coming out of your operating surplus or some other source of funding. But you should not be using your reserve fund to make any improvements to the property, including such meritorious ones as EV charging stations and other things that you would want to do to better your property. None of that comes out of the reserve fund. Reserve fund is for repair and replace. Good question. Really good question. Dave, one quick question. AGM is supposed to be held within 6 months of fiscal year end. We missed it. Oh no. What are the consequences of missing the deadline? Condo law does not say. So, Dave, this question is often answered with a condo cliche, which is to say that there are no condo police. So there's no clear consequence to missing the AGM 6-month deadline. The answer is just call the meeting as soon as you can, and you'll hold it when you hold it. And condos miss these deadlines all the time, and as long as you do the best you can to hold the meeting, you will not likely suffer any consequence. But you should hold the meeting, so do it. Call the meeting, 35 days, hold it, just get it done. And there's no like fine or anything like that for missing it. All the directors, terms of offices, the auditor, everyone stays in office until you have the meeting and there's new people are elected. So that's it. Harland. Does a mask have to be worn by the security guard even if there are plexiglass barriers around the security desk? Is the rule the same in Vaughan? Harlan, I would have to check to say if the rule is the same in Vaughan as it is in Toronto. But my answer to you is they should be wearing masks. If the guards are going to necessarily have contact with residents, and the plexi barrier is like one layer of protection, but they should still be wearing a mask. So yeah, put masks, and I can check the rules if it's like mandatory. I suspect it probably is, and they should be wearing masks. Also remember, masks are mandatory anytime you are in a condo common area. So that's true across all of Ontario. So you're going to have a situation where I think, yes, they should be wearing masks. Anyone in the common areas of your condo, including your security guards, your cleaners, all those people should be wearing masks. Barriers or not. Dreadbane. If an owner requests a draft board meeting minutes that are not approved by the boards, are we allowed to disclose it? Are we allowed to provide the dates that said meetings were held? You're allowed to disclose it, but you don't have to. So this is a question about records. And the question is, do you have to disclose draft minutes? And the answer is you do not have to disclose draft minutes, but you could if you wanted to. You would just say these are not the official minutes because they haven't been approved yet. Should you do it? No, because if you do it for one, then you're going to have to do it for everyone. And it sets a bad precedent, and I think you should just say to the person, wait for the minutes to be approved, and then we'll send them to you right away. And that is the best way to deal with it. Should you provide the date that the meetings were held? Yeah. If someone asks you when were the board meetings so that they can specify like which meetings they want minutes for, that's totally fine. You should tell them when the meetings were. Okay, Cheng. During the current state of emergency, is it allowed for the unit owner to install EV charging station in her own parking stall after the board approved her application? That's a good question. Probably not right now. I think all that stuff is on pause because what you have is a lockdown order, which we haven't got to yet. But in the lockdown order, they talk about construction, repairs, and renovation, and they basically say that you can continue construction work that was started before January 11th or January 12th, sorry. So in the case of an EV charging station, like an improvement to a parking space, if the work hasn't started yet, you're probably not allowed to do it under the lockdown, and I think you have to wait until construction activity reopens, and then you can do it, since it's not like a mandatory repair for safety purposes or anything like that. So I think you're caught in the lockdown, and you're not going to be going ahead with that until circumstances change. Might only be a few weeks. So I would say maybe you would even like sort of tentatively plan it, like schedule it for April or something, and then hope for the best. I think that's probably the best way to do it. Pete, if an owner has a dispute with the condo corp regarding a chargeback of a repair and decides to go to small claims court to fight it, if he does not pay within 90 days, can the corporation still register a lien? Yes, and you should, because you don't want to lose your lien rights. So if you say that this is a proper chargeback and you can support it under the Condominium Act, and the owner doesn't pay it, well, first of all, how is the owner going to small claims court if they haven't paid? There's no damage, right? They should only be going to small claims court if they've paid and they want the money back. So that right there, the owner is going to have a problem. But the answer is yes. Put your lien on, and then leave it there pending the outcome of the small claims court case. Don't enforce your lien. Don't go like power of sale or anything like that. Wait for the litigation to be finished. Then, once you've got all your costs and everything, then you can assess what you're going to do with your lien. That answers your question. Great question. Nita, hi Brad. Can the COVID-19 disinfection expense go out of the reserve as an expense related to the safety of residents? That's interesting. No, I don't think you can. Um, uh, Cleaning is a classic maintenance item. It is not a major repair or replacement, so it's not a reserve fund expense. That's the short answer. It's just something that should go out of your operating budget. WC. Hi, Brad. How would the board be able to obtain corporate legal advice pertaining to the current management company and the corporation without the management knowing due to sensitive information? Just you, as a board, you would have a meeting, and then you would have part of your meeting which is, quote, in camera. And in camera actually means not like private or secret or anything. It means only the directors. So an in camera portion of a board meeting means that the manager and perhaps even the minute taker is excluded, and just the 5 directors, or 7 or 3 or however many you have, meet among you. And then at that portion of the meeting, you would take your own minutes, like have the secretary take the minutes, and you would resolve to retain a lawyer, and you would appoint the president to be the liaison, and you would contact the lawyer directly, and you would do all of that, and you would instruct the lawyer to send invoices directly to the president, and the lawyer can also, in the lawyer's invoices, the wording can be sufficiently, not vague, but like general. I guess general is the word I'm looking for, not vague. The general can be like advice to president, right? And it's not what the advice is about. And the manager can process the invoice just like any other. And that's how you do it. So if that answers your question. Yeah, so it's hard. It's hard to think about, like, how do we get advice about the manager? But it can be done, and that's how you do it. Phil, is there a time limit from the condo authority for a condominium to comply with the 3 directors to take the course? Yes, there is a time limit, 6 months from the date that the person was elected to the board. And what happens if you don't take it? You're disqualified from the board. You're no longer a director, and you have to get a new director. So the answer is yes, you got to do your training within 6 months. And if you don't do it within 6 months, you're automatically disqualified from the board. So it's just like automatic. It's not, no one like sends you an email or anything. It happens automatically. So you want to keep track of those deadlines, and if you think you've missed it, you want to appoint a replacement director. Phil, is a reserve fund required for all condominium corporations? There is one exception. If your condominium corporation has less than 25 units and all of the owners consent, like 100% consent. Oh, wait, sorry, that's the audit. Yes, reserve fund is required for all condominium corporations. There's an exception to some condos. They don't have to do an audit every year. You can pass a unanimous resolution of owners to exempt yourself from an audit if you're under 25 units. But all condominium corporations require a reserve fund every 3 years. So I know it seems like a unnecessary expense if you own all the units yourself, but you should comply with the act, because it's what the legislation requires you to do. So if you're a condo, do it. WC, for NOICs, new owner information certificates, do you agree that some management companies should charge a fee of $40 for each NOIC to be issued to owners? Many don't, but some do. No, I don't agree you should charge a fee. Condominium corporation has to issue it. It's not something that's done at the request of the owner, so there should not be a fee, and I don't think you can. Paulette, regarding security officers wearing masks, what if they claim they can't wear a mask and their company is saying that it's against the guards' human rights to insist on them wearing a mask? Make them wear a face shield instead. If they can't wear a mask because it's a they have some sort of breathing disability, then they should wear a face shield. Yeah. I mean, the guard's not wanting. If you were a guard, wouldn't you want to wear a mask? Like, wouldn't you think to yourself, like, geez, I should wear a mask? Especially if you had, like, asthma or something that made you, like, more susceptible to COVID. I would be really, like, strong on the mask thing. If I was a guard, I would be like, mask for me. I would probably wear 2 masks. Harland. For Phil, inform him that the CAO enforcement officers know about him and will be paying him a visit. Harland and Phil are teasing each other through the chat. Play nice, Harland. All right, let's talk about lockdown a little bit, because we've had a few questions on it, and we'll just go over some of what's what's going on right now until at least February 19th, recently extended. So lockdown until February 19th. Let's see what's going on. So we talked about work from home. That's the stay-at-home order. Now let's talk about lockdown. Okay. So I went through the lockdown regulations, like brand new. They're not all new regulations, but I went through them fresh, just to sort of, take a fresh eye to all the stuff that I've been looking at for the last year. And so one thing to know about the lockdown regulations is it's divided into 5 schedules: part 1, 2, 3, 4, 5. And so part 1 is general, part 2 are businesses that may open, part 3 are places that are closed or subject to conditions, part 4 is public gatherings, and part 5 talks about emergency childcare and has no relevance to condos. So general rules: businesses that are allowed to stay open, places that are subject to conditions, think about your amenities, and public gatherings. Those are the 4 categories of things that we're going to talk about. So let's talk about first the general rules. What's relevant to condos? So the first thing that you're going to find in there is that the legal responsibility to ensure compliance lies with the condominium managers and the boards of directors. And then you're also going to find the rules relating to short-term rentals in the general rules, which talks about the fact that short-term rental accommodation, less than 30 days, can only be provided to individuals who are in need of housing. So that means no tourism, no travel, no vacation rentals. That's in Section 1. Now let's move on to Section 2, businesses that may remain open. So you might remember this from the spring as the list of essential businesses or essential workplaces. So that's where you'll find that list. It's in Schedule 2 to the rules for Stage 1. And you're going to see all kinds of stuff that is relevant to condos that stays open. So snow clearing and landscaping stays open. Security services for residential buildings and corporate buildings and other properties stays open. Domestic services that support children, seniors, or vulnerable people. So if you have housekeeping or people coming in to cook or do outdoor or indoor cleaning for people who are vulnerable or older, childcare, all of that stays open. Moving and delivery, so move-ins, move-outs. Temporary staffing is all open. Home child care stays open. Real estate agents are permitted to show a property in person by appointment, but no open houses. To me, that's an odd one. I would say that it should probably be like only when necessary. But if you go on RICO's website, they'll say only do showings in person when it's truly necessary. Property management as well as property maintenance and repair services are all considered essential and remain open. But that doesn't mean you don't have to work from home if you're able to do so. Residential renovations, if the construction work started before January 12th, we talked about that. And then if there are, so where the rules relating to common element repair projects are not totally clear, there appears to be sort of a general permission for construction related to residential condominium buildings. But, the spirit intent of this is that if you have cosmetic refurbishment projects, you're not doing them right now, you're only doing things that are considered essential maintenance and repair. Or if you've got an urgent garage that's like in danger of collapsing, anything like that, you're absolutely doing that repair project right now. That stuff is not delayed. So we'll talk about Schedule 3 in a second. Let's answer a few more questions, and then we'll jump back into it. So Peter, joining a bit late. Oh, don't worry about it, Peter. My query is about new COVID regulations. Persons returning to their condo from a trip within Canada, do they have to quarantine? Yes, the quarantine period still applies. So for condominium corporations, if you have someone returning from abroad, you would just you would go on and check the quarantine for the federal rules, make sure it's still enforced. I believe it is. And but it's not up to you to enforce this quarantine, right? Like, you don't want them walking around in the common areas. So if you see them doing that, you might say, please don't. But they're going to get checks from the from Border Patrol and stuff like that. So that's the quarantine stuff is still in force. KB, is the answer the same for PICs and ICUs? No additional fees to be charged. The PICs and the ICUs have to be sent out. So a PIC is a periodic information. We're talking about whether information certificates, condos can charge for them. You charge $100 for a status certificate. There's no charge for the information certificates. But we're talking about not when people request them, we're talking about providing them when the condo has the obligation. So for the periodic information certificate, condo has the obligation to send it out twice a year. Information certificate update, ICU, not intensive care unit. You're sending out the ICU whenever there's the material change that requires it to be sent out. So for example, a change in the composition of the board of directors after your AGM perhaps would be a time when you send out your ICU. And there again, there's no charge by the condo to the owner. It's the condo's obligation to send out that notice. So, yeah. WC, if the board is contemplating changing management companies but does not have the experience to facilitate the process, would that be something the board should talk to the condo lawyer to assist? You could talk to us. We could certainly point you in the right direction. There are also people who are, self-styled management consultants, and they will guide you through the process and go out and get bids for you. So that is a service that some people in the condo industry provide for a fee. So if you're not sure about management companies and you want to do due diligence or have someone help you, you can absolutely hire a consultant to help you pick your property management company. Or you can ask the lawyers, and I'll give you 10 names, and you can interview whoever you want from that list. That's something that I can do as well. Would you, meaning me, recommend the board to provide management companies the actual management contract for their consideration to provide? Would you recommend the board provide management companies the actual management contract for their consideration to provide a proposal back? Okay, so if you're seeking proposals from property management companies, I would not take your current contract and send it out when you're asking for proposals back. I think you're disadvantaging yourself if you do that, because then the person sending you a proposal knows how much you're paying for management services. And if they know, for example, that you pay $100,000 a year, they might quote the same price, but if they hadn't known, they might have quoted you a lower price. So I would be careful about that. I would just tell them what your service level is, whether you need a full-time manager or like what your expected scope of work is, part-time, whatever it is, and then they'll quote you a fee based on basically their labor cost plus back office cost plus a profit margin. That's how they quote. That's how they calculate the fee. They just take whatever the salary is that they're going to have to pay the manager. They add a certain percentage. They add overhead costs, and then that's what you pay. So, Cheng, hey Brad, do you recommend having a one-way walk sign in the lobby floor? Yes. In fact, when you check Dr. DeVella's letter, you'll see that it's required. So yes, you should have one-way walking signs in your lobby, pointing people in sort of like a circle around each other so they don't crowd. Yes, you should do that. Paulette, they say they can't wear a face shield either. We're having a real problem at one of the sites. So this is the security guard. Okay. So, and apparently we can't move them to another shift, less noticeable. Paulette, I don't think that they're being honest with you. I think you have like an anti-masker guard, and I would talk to the security company about that, and I would say that like the person who they've got to wear a mask, and if they have an exemption, they've got to wear a face shield. So the city of Toronto District School Board had this problem when they had in-person school with staff not wearing face masks and claiming medical exemptions, and the response of the Toronto District School Board was to require anyone who had an exemption from the face mask requirement to wear a face shield, and they enforced it. So I think you could do the same thing in the setting of a condo. You could just say, look, you don't want to wear a mask, you wear a face shield, that's the deal. And if they say no, then I would take them out of the site. I'd say you can't be here. People have to be masked to do the job. And very, very sorry. Too bad, so sad. I know it seems harsh, but like I do not believe that there are people out there who can perform the job of a security guard, but who cannot wear masks. The idea of a medical exemption for a mask was not meant to cover, otherwise healthy adults. It was meant to cover babies and people who were disabled to the point that they could not put on and remove a mask independently, or people with severe breathing difficulties. And if you had any of those conditions, it would be very unusual that you would choose a security guard as your line of work. So I don't see how this is a legitimate objection from this guard. It's so unlikely to me that I think you would be relatively safe to take a strong posture against it, because you have to put the health and safety of the community first. Cheng, what about owners requesting a hard copy of the ICU or PIC? Better to mail out instead of delivery by security. Better to mail out or delivery by security guard? You should deliver the ICU or PIC in the same manner that you send out your notice of meeting when you do a meeting of owners. So if you normally send it in the mail, then you put them all in the mail. And if owners receive notices by email, then they should get it by email. And that would be owners who have provided a written consent to receive notices by email. So I would say, yeah, mail or email. That would be, and the other thing you can do is, if people who received it by email want a hard copy, you could just have extra copies available at the desk or something for people who want them. No harm. Or in another scenario, they can make a records request and they'll receive it. They'll receive it without a fee under the records request regime. So there's no point in asking for money for it. Just give it to them. Bruna, we have heard that enforcement officers are doing rounds in condo buildings re-pandemic signage. Do they have the right to enter the common elements and issue fines? Do they have the right to enter the common elements? Well, certainly they have the right to issue fines. You have to have a sign in when someone is entering the building. So like all of your entrance doors saying like masks are required. If you're in the City of Toronto, you have like the City of Toronto mandatory mask sign. But that sign has been up on the City of Toronto's website forever, and you can just download it, print it, put it up. They might also be checking for things like floor markings or whatever, and I would say if they ask to enter, you probably do have to let them in. I can't imagine that they wouldn't have the right to enter your common area, so let them in. Okay, so I've caught up on the questions, and Cheng, some residents refuse to wear masks because they don't believe that masks do anything to stop the virus. So what do you do about anti-mask residents? What can the condo do, and how to enforce? So, okay, this is a real thing. Okay, so we're not talking about people who claim that they're exempt for some medical reason. We're just talking about people who are like anti-mask. And what do you do about these residents? I would enforce it the same way you enforce a condo's rules. So you would, send an enforcement letter from management saying, look, mask rules apply whether you agree with the philosophy of whether masks should be required does not matter. You are required to wear one. And so we can help you draft a letter like that. And then if they're still not complying, then you can basically refer it to the lawyer, and it might be, depending on what your condo declaration states, may be able to charge back legal costs. So it's something like a fine. And then, of course, in an extreme case, you can call bylaw enforcement. But I mean, it's hard for the bylaw enforcement to be there at the moment to catch them. So, and you might be sort of inviting more trouble than it's worth when they come into your common areas. But yeah, just enforce it the same way you enforce your rules: management letter, legal letter. And that's the best you can do. It sucks, man. People suck. They don't want to wear masks, and we've got bigger problems than whether we should or shouldn't wear masks. Alfred, as a property manager, can we request the owner to provide proof of the letter that they are exempt from wearing a mask? So the answer is no. You're not supposed to ask for proof in the form of a letter. Both the provincial rules about masks and the City of Toronto rules about masks, they both say that a person is not required to provide medical proof of a disability for an exemption. They just have to say that they're exempt, and you're supposed to accept it at face value. But I got this question before, and I will give you the same answer that I've given to other managers, which is, how do you know when someone is lying about a medical exemption? And one way you can know if they're lying is consistency. So let's say you see someone and they're not wearing a mask, and you say, excuse me, sir, you need to wear a mask when you're in the common areas of the Condominium Corporation in accordance with provincial law. And they'll say, I have a medical exemption. You'll say, if you can wear a mask, here, I have one for you. You can offer them to. And they say no. Okay, great. And then maybe, let's say a few days later, they are with someone And now because they're like with their family member or whoever, they are wearing a mask because now they want to they don't want everyone to know that they said this thing that wasn't true. So they're wearing the mask, right? Because they're with someone else, or maybe they're just wearing the mask because today they happen to have their mask with them that they like, and now they're wearing it. Once you've seen that person wearing the mask, they can no longer honestly claim that they're unable to wear it, right? Oh, well, you said to me on Monday that you had a medical exemption and you can't wear a mask for some medical reason. But then on Wednesday, you were wearing one. So obviously, if you can wear it on Wednesday, you could have worn it on Monday. And now you know that the person was not being forthright with you. And at that point, I would no longer accept from that person the excuse that they have a medical exemption. I would say, no, you don't. You wore a mask on Wednesday, and so you were lying on Monday when you said you couldn't. And that's that. That's what I would do, Alfred. It's my best advice about what to do about mask excuse liars. So, but don't ask for a doctor's letter. Do it the other way. All right. So we talked about our list of essential workplaces. Now I'm going to circle back and we're going to talk about your amenities. So this is in Schedule 3, Part 3 of the rules for condos in Stage 1. Rules for areas in Stage 1. We're talking about condos. So the first thing you're going to see in Schedule 3 is that all indoor recreational amenities have to be closed, and that the following outdoor recreational amenities can be open subject to compliance with like additional social distancing and safety rules. So here's what can be open. If you've got outdoor landscaped areas, parks, tennis, basketball, or other similar sport courts, playgrounds, or outdoor fitness equipment, all of that can stay open. Everything indoor should be closed. If you have outdoor recreational amenities that are open, you need to make sure you have 2 meter physical distance that's maintained. And no games are played where participants are likely to come within 2 meters of each other. No team sports. And your locker rooms, if you have those, they have to be closed, but your public washrooms can be open. So that is that's what is open for amenities. And the last thing I will mention, Part 4 of the lockdown rules, is no indoor gatherings. Outdoor gatherings limited to 5 people. So what's an exception to the no indoor gathering? People who live alone can gather indoors with members of one other household. The prohibition on indoor gatherings does not apply to a business that's allowed to be open. So for those reasons, and because there's lots of different legitimate reasons why people might go to a condo, I don't suggest that you take a no visitors period policy. I think you have to be a little more flexible than that. And you want to err on the side of being a little more flexible because the lockdown rules and the stay-at-home order are already so strict that, to me, there is really it's hard to justify saying that you want your condo to be even stricter than what we're already doing provincially. Because, like I said, stay-at-home order, lockdown order, these are really strong or harsh even. Restrictions on people's freedoms. And so as a condo, you can have policies that are more restrictive than provincial regulations, but would you do that when we're already at the most extreme end of what's being restricted? I don't think you would. To me, the principle that condos can have more restrictive policies in place than what the province is doing applies when we're doing better and the numbers are down and the lockdown is lifted and you want to say in your condo, look, yeah, the lockdown is lifted, but we're going to keep our amenities closed for an extra week or two just to be sure, That type of thing is where the flexibility for condos comes in, delaying your reopening, that type of thing, rather than locking down even harder. To me, that's not the right not the right mindset that's going to be appreciated by your owners, right? What your owners are going to appreciate is a certain amount of caution, but not like overzealousness when it comes to COVID rules. So that's the stuff I wanted to talk about. So I see there's another question in here, Harland, and we might do just like a couple more questions. So I'll keep my eye on the chat here, but we've been going hard for 50 minutes, and I'm going to wake up tomorrow with a scratchy throat from talking to all of you folks, and then I'm going to be like, oh no, I got COVID, but of course I didn't because I don't leave my house. I don't see anyone. Let's see what Harlan has to say. Is there something that can be done if the mask excuse liar is a member of the board? Oh my goodness. I would just, you treat them like any other owner, Harlan. That's the best I can say, is that the rules apply to members of the board the same as they apply to every other person, and they should be treated the same. So just whatever you would do for any normal resident who says that they can't wear a mask, if you have a known mask excuse liar, so someone who wears masks sometimes, and then when is told to wear one, claims a disability, but then goes about and wears the one the next day, you would deal with it just the same way you would any other owner. Letter from management, letter from the lawyer. No need to be like heavy on them, but just let them know that you know what's up and you expect them to comply. And if they persistently do not comply, that there can be consequences. But let's all just try to show some compassion for each other. It's a very stressful time. People are depressed and they're not they're suffering, and we just want to do what we can in the condominium industry to be safe, but at the same time not make things worse for people. So that's the sort of balance that I'm trying to strike in my practice, and I hope you can take the same approach in your building. Keep everyone safe, do what you have to do, but you don't want to make people needlessly miserable and being a COVID Karen or whatever, and just like harshing on everyone for not following the rules perfectly. It's got to be a little more flexible with each other, and as long as people are trying, that's what we want to do. Harlan, would it be considered a breach of ethics as one of the consequences? Harlan, no. You do not want to intermingle what an owner does in their capacity as an owner with what an owner does in their capacity as a director. So you generally want to consider ethics violations for directors to be something that has to do with the person in their acting in their capacity as directors. And when we talk about things like wearing masks in the common areas or parking or whatever, that's something that happens to somebody in their capacity as an owner. Try to treat it separate, and keeping that wall of difference between your life as a director and your life as an owner is, I think, a really important and healthy thing to do. You don't want to mix it all together. So yeah, all right, everyone. 52 minutes, lots of questions. Thank you so much for joining me. I've got the FAQ sheets in the video description, so you can click on those links and print them off, or save them, and we send them out by email, so you've got them in your email as well. Thank you, everyone. I'm not sure who's on next week, but we look forward to seeing you again, and if you're not a subscriber, please do subscribe. Stay safe, everyone, and we'll see you soon. Bye for now.